You're listening to continuing coverage of the Abby Zwerner civil trial from the Hidden Killers podcast and True Crime Today.
All right, ladies and gentlemen, in the courtroom, if you are a member of the media and were permitted a recording or cell phone in, please make sure that is on silent during the course of any time that court is in session. I will address the jurors just real briefly about the media presence in courtroom. I didn't do that yesterday to the entire group, but I will do that to the group who is sitting today. And then we will allow them notepads after their opening statement. All right. Very well. Bring in the jury.
Your Honor, just administratively, once the jury is seated, I intended to go ahead and pivot that television for their view.
All right, just don't hit my walker.
We already spoke about it.
I guess if he doesn't do it.
Please rise for the jury. Nine jurors in the box, Judge.
All right, thank you. Do you request a poll, Mr. Benazian?
I do not, Judge.
Yeah. Do you request a poll, Ms. Douglas? All right.
You may be seated.
Good morning, ladies and gentlemen. All right, we are going to proceed with opening statements this morning. There were two things I did want to advise you of. Obviously, we have a media presence here today and in the courtroom. There are cameras in the courtroom, but I want you to know that under state law, the media is prohibited from covering the jury or any jurors at any stage of these proceedings, including the jury selection process. I have been in touch with the individuals who are here doing that, and they have promised me that you will not at any time be on any video or mentioned at any time. All right, the second thing is, I know I promised you notepads. However, we will have those available for you after opening statements when we begin evidence. All right, having no other motions to make, you may proceed with your opening statement.
And may it please the court, Your Honor. Good morning, members of the jury. In every school, there are spoken and unspoken promises that teachers trust administrators to keep. One of those promises is that when teachers sound an alarm that something is wrong, administrators will answer. In this case, on January 6, 2023, those promises were broken. And those promises were not broken by chance or confusion, but through a series of deliberate decisions that were made inside Richneck Elementary School, a school right down the street from us, 15 miles, in our own community. And you're going to hear about the defendant, Dr. Ebony Parker. She was the assistant principal on January 6, 2023. At Richneck Elementary School. Now, members of the jury, an assistant principal is the second in command. She's a frontline administrator. And as a frontline administrator, the assistant principal directly interfaces with the teachers every day. Those teachers go to her for support. They go to her when there's problems in the classroom. And those teachers go to her when there are safety concerns. And you don't have to trust me on that. You're going to see during this trial copies of the school handbook the crisis management plan, which governs these responsibilities. And it also governs the relationship between administrators and teachers. As an assistant principal, you have the authority to search a student, to remove a student from the classroom, to notify the principal, to contact law enforcement. One of the main issues of a frontline administrator is safety. We've all heard safety first. Members of the jury, this is the job of an assistant principal, the job that Dr. Parker accepted with those spoken and unspoken promises, with that authority that she undertook as the assistant principal. Now let's talk about January 6, 2023. The first week back to school after the holiday. Kids are excited, there's excitement in the air. It's a Friday. There's about 100 kids that are filing in to Richneck Elementary School at about 9 o'clock that morning. 20 of whom are headed down to room 11. Room 11 is the classroom that Ms. Zwerner was the first grade teacher of. Now it's January, it's cold out. These kids have on hoodies, jackets, and backpacks. And in those backpacks are things that you would expect to find. Books, pencils, calculators. About an hour and a half later, at 10:30 a.m., another student, a 6-year-old, who we're going to refer to as JT, comes to school. His mom drops him off. You may be wondering why JT got to school at 10:30 that day. You'll probably hear that he was on a modified schedule because JT had some behavior problems. He was also coming back to school that day from a suspension where 2 days prior, JT had a violent episode where he took Miss Zwerner's phone and slammed it, cracking the screen protector. So this is his first day back from the suspension as well. JT too has on his backpack. He checks into the office. In JT's backpack are the usual things: books, a calculator, pencils, but you're going to hear that JT also had a loaded gun. So JT goes down to room 11, which is right down the hall from the main office, where the assistant principal's office is, where Dr. Parker spent the majority of her day sitting at her desk. You're also going to hear that it was makeup testing day. Opposing counsel may say that's an important day in the life of an administrator. And it is. They're doing makeup testing. It's about 30 students that day from grades 3 through 5 who are making up the testing. It's a very small percent. Now it's about 11:30, 11:40, about an hour's gone by. Ms. Zwerner goes into Dr. Parker's office. She's sitting at her desk. And Ms. Zwerner says to Dr. Parker, JT seems off today and in a violent mood. He just threatened to beat up a kindergartner in the cafeteria. Does Dr. Parker get up from her desk and go down and check on JT? No. Does Dr. Parker look up and address Ms. Zwerner and her concerns? No. Dr. Parker does not even look up. So now, some more time's gone by. It's a little after 12. You're going to hear that another teacher comes into Dr. Parker's office, Amy Kovac. Ms. Kovac comes into the office with an alarming report and says, after she's been in JT's class, spoken to some of the students in JT's class, Ms. Kovac thinks that JT may have a gun in his backpack. So, does Dr. Parker remove the child from the class? No. Does she notify the next in the chain of command, the principal? No. Does she contact law enforcement? No. Does she search the backpack herself? No. So Ms. Kovac says she's going to go search the backpack when they go to recess. Now about maybe 20 more minutes or so go by. Ms. Kovac comes back to Dr. Parker's office, where Dr. Parker is still sitting at her desk. And now Ms. Kovac says to Dr. Parker, I checked the backpack. There was no gun. right? However, in her next breath, Ms. Kovac says, Ms. Zwerner thinks that the child, JT, took something out of his backpack, the gun, and put it in his pocket. Does Dr. Parker then decide to remove the child from recess while he's out there with all the other students? No. Does Dr. Parker search the child? No. She doesn't notify the principal. Instead, Dr. Parker downplays the report. And she says to Ms. Kovac, he has little pockets. So Ms. Kovac leaves. Well, Ms. Kovac's one of the proctors that day for the makeup testing. So she goes out to recess and comes back to see Dr. Parker one more time. This is Ms. Kovac's third time in the office. It says, I wanted to let you know he has on a jacket and I'm going for the testing because it starts at 1 and she'll be back for the testing. Now some more time goes by. It's about 1:40. 2 additional staff members go to Dr. Parker. One goes into Dr. Parker's office and says, he just got off the phone with another first grade teacher. He wants to know, did you search JT? Dr. Parker says, yes, the backpack's been searched. He walks out. Shortly behind him comes in the guidance counselor. And he says to Dr. Parker, after speaking to others and being concerned that a student actually saw bullets or a gun in JT's pocket, says, can I search JT? So not only does Dr. Parker not leave her office and go down the hallway and take JT out of that classroom, not only does she not search him, she doesn't call the police, but she makes the decision to say to the guidance counselor, no, you cannot search the boy. She says, just wait. His mother will be here soon. Let her know. The mother gets there about 2:30. This is about 1:40 p.m. We've had a day now of warnings. 4 warnings. So now the time is 1:58. Bang! Everybody nearby hears the sound of a gunshot. JT has now taken that firearm, pointed it at Abby, and pulled the trigger. You're going to hear that that bullet went into her hand, her left hand, through her hand, into the side of her left chest, where it still lies today, because it's too dangerous to remove. You're going to hear how January 6, 2023 changed Abby's life forever. She has undergone 6 surgeries and still has one coming up to remove a plate out of her hand. And you'll be able to see her hands, the difference. She still does not have full range of motion in her left hand. And you're going to hear from those doctors, and they're going to tell you about that impact from that gunshot that day. You're going to hear from her sister Hannah and her mother Julie, and how they had to give Abby around-the-clock care for months. Hannah quit her job. Hannah moved in with Abby so she could take care of her around the clock. Because jurors, Abby could not open food containers to feed herself. She couldn't open bottles. She wasn't able to shower. She couldn't hold a brush for her hair or wash her hair. She wasn't able to pull her pants up. She wasn't able to button her clothes. She wasn't able to drive. Abby was 25 years old on January 6, 2023. She had just started her career as a teacher. She was pouring into her students. She was excited about what the future held. In your 20s, usually some of the best times of your life, Abby's going to tell you how they've been the darkest times of her life. how the pain and trauma do not easily fade, and what she's been dealing with. And members of the jury, you're going to hear from an expert who's going to tell you that administrators are trained how to deal with the report of a gun in school, and how ignoring multiple credible reports of a firearm not only violates protocol, but it puts all lives in danger that were in that school. You'll hear from all the teachers that went to Dr. Parker on that day, the 4 different staff members and teachers, with their concerns that JT has a gun. And you're going to hear from the defense that you should excuse Dr. Parker's conduct on that day. You're going to hear Dr. Parker was part of a team of teachers prior to January 6th that were working with JT to try to help correct some of those classroom behavior problems he had. And that's true. You're going to hear that it was a 6-year-old child. Who would think a 6-year-old is going to bring a gun to school and shoot their teacher? Members of the jury, it's Dr. Parker's job to believe that that is possible. It's her job to investigate it and to get to the very bottom of it. And to hope that that's not possible. But her job is to address it. You're going to hear, Abby could have done more. But when you hear those arguments, I ask you to ask yourself, why did 4 different people go to Dr. Parker that day with this concern? 4 different staff, 4 different teachers total went to Dr. Parker. Because Dr. Parker was the assistant principal. Dr. Parker was in the chain of command. Dr. Parker had the authority to search a student. She had the authority to remove a student from the classroom. She had the authority to call the law enforcement. 4 opportunities to take decisive action and do that. So jurors, why are you here today? You're here because we're asking you to enforce a promise that Dr. Parker broke, and a life has been shattered because of it. Only you have the power to decide how to make up that promise, and only you have that power to decide what are those harms and losses that Abby has suffered. And it's important, jurors, that you don't have to find that Dr. Parker is not a good person. We're not even suggesting that. We're asking you to look at the decisions and choices that Dr. Parker made that day, because she made bad decisions and choices that day. But you can find that Dr. Parker is a good person, but you can also find that Dr. Parker breached her duty of care to the plaintiff on January 6, 2023. And I ask that you please listen carefully to each witness that you're going to hear from over the next 2 weeks. You're going to get to watch and hear testimony about what happened in that school on January 6th. You're going to see documents of handbooks, of protocol. You're going to hear from doctors. You're going to hear from experts. So please pay close attention to all of that. And also notice each time Dr. Parker had a decision to make, what that decision was that Dr. Parker made. How many opportunities Dr. Parker had to prevent what happened on January 6th. And I'm confident at the end of this, you'll have a clear picture of what happened and how that tragedy on January 6th happened. Minute by minute, decision by decision. And I'm going to ask at the end of this trial, we're asking that you come back with a verdict for our client, Abby. Thank you so much for your attention this morning. I appreciate it.
Thank you, Mrs. Bell. Do you want this on the record?
I think so.
All right, before the defense proceeds with their opening statement, if there are any subpoenaed witnesses in the courtroom, I would ask at this time that you step out of the courtroom and into the waiting room, and counsel will be with you after the statement. For the record, I understand there's a joint motion to exclude witnesses. Is that correct, Mr. Bin?
Yes, Your Honor.
Yes,
Yes, Your Honor ruled on that yesterday.
Thank you very much.
Yes.
All right, are you prepared with your opening statement?
Yes, Your Honor. May it please the court
You may.
have permission to move about the law, please?
You may.
No one can see this coming. No one can see this coming. No one could predict what happened. Hindsight is 20/20. These are not my words. In the course of this trial, the evidence will show that these are the words of the staff and teachers who will hear from in this case. These are the people who were present and were affected by the shooting that occurred, the tragic shooting that occurred at Richneck Elementary School in January of 2023. These are the words of Dr. Ebony Parker's accusers. Their accusers. These are the people who were her coworkers. They were her colleagues. They were people that relied on each other to make decisions. They were people who understood that a public school setting is a community and decision-making is cooperative. Although there is hierarchy, decision-making is collaborative. Those at the top, the so-called administration, depend on reliable subordinates, but they are equals. They are equals in the sense that everyone must exercise independent judgment and discretion. They need to use their minds. The world is a complicated place. There are no easy solutions. There are no simple stories. The law recognizes this. The law recognizes that there is such a thing as hindsight bias. Fine. Hindsight. Everyone's heard the phrase, hindsight is 20/20. You've heard different variations of this. There's Monday morning quarterbacking. This is something that is embedded in the fabric of our life. It is common sense. It is also something that is a bedrock of our system of justice. The law knows that it is unfair. It is fundamentally unfair to judge another person's decisions based on stuff that came up after the fact. We all know this. We don't need a law textbook to tell us this. We know it in here. We know it in here. And guess what? That is Virginia law as well. The law requires you to examine people's decisions at the time that they make them, in light of the information that they had. Why would the law do that? Because that's how people make decisions. None of us, no one sitting here, not me, not anyone in this courtroom, makes a decision with the benefit of hindsight. And that's a hard thing to get past. It's a very difficult thing to get past because when you hear about the tragedy, No one's disputing this is a tragedy. When you hear about what happened to Ms. Warner, we know this is a tragedy. We know this should not have happened. But you will hear from Dr. Parker's former coworkers, her associates, her former confidants. They will tell you this evening. They will tell you. Or they did. They told law enforcement. They told investigators. They told numerous people after the fact. No one could have predicted this. No one could have seen this coming. No one could have imagined that a 6-year-old first grade student would bring a firearm into an elementary school and shoot their own teacher. And this just isn't like speculation. This isn't something that a lawyer is making up. You will hear it from your own witnesses. You will see it with your own eyes. You will see surveillance. You will see video testimony. You will hear from experts. And you'll be able to judge for yourself whether or not this was foreseeable. That's the heart of this case. But as everything in law, it's always a little complicated. Nothing's simple. And what I mean is this. There's at least 2 or 3 unusual aspects of this case. I told you that the law recognizes that people make decisions in the moment. You can't judge them with stuff they didn't know at the time, with the benefit of hindsight. You don't judge it based on because this tragedy happened, it was terrible, it was a horrible outcome, therefore someone needs to be held accountable. That is not how the law works. And even if you decided, when you hear some of this testimony, you think to yourselves, I would have made a different decision. I would have made a different call. That's not the standard either. It is difficult, I know. But you were selected. You sat through that painful selection process all yesterday. That was for a reason. You were selected for a significant special purpose. It's because you were selected because you can be fair, you can be impartial, you can be unbiased, and you can view the facts of this case like no one's looked at it before. You talked about in voir dire, a fancy word for jury selection, all the media coverage, all that's been going on. We're in a court of law now. We're in a court of law now. And that's when you get to hear the facts. That's when you get to hear from the witnesses themselves who will have to come and sit in that stand and look at Dr. Parker and face her and confront her. And say to her face that this was foreseeable. This case is unusual. Ordinarily, under the law, in any negligence case, you got to prove certain elements. That's always true. Elements are the bits and pieces that make up a claim. They got to prove that Dr. Parker owed these people a legal duty, that they breached that duty, that they caused Ms. Werner's injuries, and they can establish the damages. That's true of any negligence case. One thing that will be hard to grapple with in this case, and I know, and I want to give you a preview now. When it comes to a legal duty, usually the question is easy. You just look up in a law textbook, you look in the code, it's written down someplace and it says, the law requires you to do this. The law requires you to do that. The law requires you to not do this, not do that. It's written in black and white. And if we had that type of case, this would be much easier. We don't have that type of case. This is a case where the plaintiff has alleged that my client has assumed a duty. Assumed a duty, meaning that under Virginia law, even if the law does not impose an obligation on you to do something, even if it's not written down somewhere in a book that says Mr. Hogan has to do this or that, sometimes you can volunteer for it. You can raise your hand and say, I'm taking on that legal duty. I'm taking on this obligation to do something that the law doesn't require. It may seem crazy, but that's what it is. That's how it works. And you're required to apply that law. But because that is such a significant undertaking, to raise your hand and volunteer to do something that the law doesn't make you do ordinarily, you got to meet some very stringent requirements. And you'll hear about that. The court will give you instructions in the law, will give you guidance. We'll come back up here and explain it the best we can. But what it comes down to is in a case like this, where there is a 6-year-old child, something so unusual, and you'll hear the testimony will establish this is not an everyday occurrence. In fact, it is virtually unprecedented. In a case like this, where it is done by, when someone suffers harm due to somebody else pulling the trigger of a gun, that is third-party criminal harm. That is third-party intentional harm.
Your Honor, I hate to do this, but I have an objection at this point.
State your objection.
Your Honor, he is certainly going beyond the scope of what is allowed in an opening statement and getting into argument. I restrained from arguing the case, and I'd ask that he do the same, Judge.
You have a response?
I do, Judge. I think that we gave counsel wide latitude in voir dire and jury selection to instruct the jury in the law, make sure that they can abide by those instructions. That applies here as well during opening statements. I'm not arguing the law. I'm stating black letter law and making sure that they understand how they should have the framework so they can make sense of this case.
I'm going to overrule the objection.
Thank you, Judge. I'm not going to give you a law lecture. You're going to hear plenty of that later. But what you need to know is that in a case like this, where someone pulls a trigger and it wasn't Dr. Parker, if you raise your hand to say, I'm assuming a duty to exercise care to safeguard you or protect you, when the law wouldn't make me do that normally, you have got to have a promise. You've got to have an agreement. It's got to be express, meaning you got to say it. It's got to be unambiguous. And you heard counsel mention that she had to acknowledge it and say she claims that Dr. Parker made this promise just by being an administrator, by raising her hand and saying, I want to be a public servant. I want to come here and I want to educate the children in my community. By raising her hand, she signed up for this. You be the judges of that. You all be the judges of that. The other unusual thing about this case is that ordinarily, the standard is the reasonable person standard. What that means is when you're figuring out when somebody makes a decision or not, you got to decide, okay, was this a violation of the law or not? Are they liable? The way you assess that is from a reasonable person standard. You just imagine what would an objectively reasonable person do given the information the defendant had. In this case, we got to go beyond that. For them to prevail, for them to recover, they need to establish gross negligence. That means that even if it was reasonably foreseeable, even if Dr. Parker or any other defendant in this type of situation should have known or should have known what was going to happen, but that's not sufficient here. They need to show gross negligence, and what that boils down to is indifference. Indifference, not inadequacy. That is what you need to remember. Remember that as you're listening to the evidence. Indifference, not inadequacy. What that means is if you hear the evidence, we come back up here at the end, and you're thinking to yourself, I would have made different decisions. I don't agree with what happened here. It's not the statement. They need to establish indifference. They have to establish that our client, Dr. Parker, exercised not even the slightest degree of care. If the evidence shows after everything shakes out, and you decide and you consider it, and you come to the conclusion and you think, look, I would have made different decisions, but you can see the evidence establishes that she exercised some degree of care, she did something, even if it turned out to be insufficient, That's the law you need to apply in this case. That's the way you need to think about this case. Carry that with you when you listen to the evidence. Carry that with you when you listen to these witnesses take the stand and tell the story of what happened. Because you are the judges of credibility. You have to decide who's telling the truth. And you heard in jury selection, counsel emphasized, he asked you to be brutally honest. Brutally honest. That's what the law requires of you. He's right about that. Ask if these witnesses are being brutally honest. Think about that. The last thing that you should know about this case, that you should consider as you're listening to all these witnesses take a stand, is that there's another duty we gotta talk about. Every person under Virginia law has a duty to exercise reasonable care for their own safety. It's common sense, just like how hindsight is common sense. The law knows that. The law accounts for it and says that should be the law. You got a duty to exercise reasonable care for your own safety. And what you're going to hear in this case is evidence that will give you pause. Counsel asks you to think about every time Dr. Parker had to make a decision. I want you to think about every time Abby Zwerner had to make a decision. Think about that. Is she being brutally honest? It's a hard thing to do. Under Virginia law, if you're even slightly at fault and you fail to exercise reasonable care for your own safety, you generally cannot recover. There are exceptions, you will hear about them. I'm not here to lecture you on the law, but you need to know this. You need to know this to understand the story you're going to hear, because this story hasn't been told for real before. Ms. Douglas is going to get back up here at the end of this case. She's going to ask you to hold true to the promises you made during jury selection, that you will follow the law, that you will listen carefully to the evidence, you will weigh it, and you will come to a judgment. What I want you to think about, you are not judging Dr. Parker's conduct. You are judging the evidence. Apply the law. Think carefully and ask yourselves, is it really foreseeable that a 6-year-old child would shoot their own teacher? Is that reasonably foreseeable? Was Dr. Parker indifferent? Did she fail to exercise at least some degree of care, even if it didn't work out? Did Abby Zwerner fail to take steps for her own safety? That's what you got to think about. Those are hard questions. Think carefully. You get one shot at this case. In jury selection, counsel talked about one of your roles. Your roles is like assessing the value of a diamond. Like it's a prize. There's a cash reward at the end of this case. You gotta assess it. This is not the Antiques Roadshow. This is a court of law. You assess witness credibility, which will be decided in the crucible of court. You will look at them. You will decide. You are deciding people's lives, careers. That is what is at stake. It is not a diamond. Apply the law. Trust your instincts.
Thank you, Mr. Hogan. All right, are you prepared with your call your first witness?
We are, Judge. We plan to call Nina Farish.
All right. Mr. Benioff, everything that's going to be on that screen is going to be on this
Yes, sir.
for me to see? Okay.
And it will be there for the witness as well.
Right.
And counsel has preview screens as well.
Your Honor, with your permission, my understanding is that there might have been another witness who was present. That was not accounted for. I just asked for opportunity for a brief voir dire before they start, if that's possible.
And it was this witness?
It was this
Oh,
witness.
okay.
There were two witnesses in here.
We didn't realize that was the situation.
Okay. All right. All right, so obviously you're asking it to be outside the presence of the jury to start. Okay. All right, ladies and gentlemen of the jury, we're gonna have to take a brief moment to handle a technical issue at this point. So my bailiff is going to see you out, and then we will bring you back in as soon as we can.
Please rise for the jury.
All right, Madam Court Reporter, please swear the witness in.
Would you raise your right hand? Do you swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth? Yes.
You may proceed. All right, who is going to be questioning the witness?
Judge, if I may.
All right.
Good morning, Ms. Ferrish.
Good morning.
I'm sorry, if you could just keep your voice raised. I don't have good hearing to begin with.
Good morning.
Good morning. I'm Mr. Hogan. I'm counsel for Dr. Parker along with Ms. Douglas. I understand it came to our attention this morning that ordinarily when a court proceeding takes place, there will be a rule on witnesses making sure that anyone who will take the stand will be excluded so that in the event that there's any information that comes to light, giving a preview of what to expect in the evidence going forward, that it might affect their testimony. So that is why I'm talking to you now. I'm not here to point fingers at you. I know you're in the limelight right now. I apologize. But I just have to ask some questions to make sure that everything's above board.
Okay.
So, Ms. Farish, at what time did you arrive here? Were you here for the entire opening arguments of counsel?
Yes.
And that included both plaintiff's counsel from the very beginning all the way through the end of defense counsel's opening statements. Both, you saw both of them?
No. Just the, I don't know which side is which. Just
This is the defense.
Okay.
It's plaintiff's counsel.
I just heard plaintiffs opening.
Understood. Do you think, was there anything in that testimony that would affect the way you testify today here in court, your ability to be candid and to follow the law, to testify truthfully?
No.
Judge, if I may have the court's indulgence, speak with Mr. Benioff.
Yes. While they're doing that, can you state your full name for the record, please?
Yes, Nina Sophia Farish.
Thank you, ma'am. And can you spell your last name?
F is in Frank, A-R-R-I-S-H.
Thank you.
I'll ask 2 questions.
Are you done asking questions?
You can proceed.
All right, go ahead.
Ms. Farish, were you informed that you weren't supposed to be in the courtroom for opening statement until after the plaintiff was done with theirs?
I do not recall that.
And you've sworn to tell the truth? You're going to tell the truth?
Yes, sir.
We're ready to proceed, Your Honor.
All right. Any motion on behalf of the defense?
Offer defense, Judge.
All right. Any motion on behalf of the plaintiff?
No, Your Honor.
All right. Can we bring the jury right back in?
Yes, Your Honor.
All right. And we can just have her, and I can have her re-sworn in front of the jury if you'd like.
Sorry, Your Honor.
Just make sure that they know that she's been sworn in since they didn't see that part.
Yes, Your Honor.
All right.
Please rise for the jury. Non-jurors in the box first.
Thank you.
You can be seated.
You may proceed.
May it please the court?
Yeah,
Would you like me to move that a little bit more?
Well, and let's make sure they can see the witness stand from where they are
that's
as well. Yeah. Down there, I can't see, so. All right. Can you see the witness from the to the witness stand now? No, you still can't? Okay. Can you see over here now? If you... Yeah, I think that's probably better.
Sorry.
All right. Front row. All right, and then everyone else can see both the screen and the witness stand. All right, great. The acoustics are not great in here, so if you can speak up, they got to hear you all the way over there.
Yes, sir.
Perfect.
May it please the court?
Yes.
Good morning.
Good morning.
Could you please state your full name for the court reporter?
Nina Sophia Farish.
And Ms. Farish, is it Dr. Farish?
Yes,
Dr. Farish, before the jury walked in, you were sworn to tell the truth, correct?
correct.
And I'm just doing that since they weren't there to watch it. Normally they're there to watch it, okay?
Yes, sir.
So, Ms. Farish, can you give us a little bit of background on your current employment position?
Currently, I am the Director of Human Resources for Newport News Public Schools.
And did you serve in that same role or capacity back in 2023, specifically January of 2023?
Yes,
And as part of your role with the Newport News Public School System, did you, as a result of a shooting that occurred at Richneck Elementary on January 6th, perform an investigation?
yes,
And as part of that investigation, did you interview Dr. Ebony Parker?
yes.
I'm going to show you just a roadmap, which is... Go ahead and publish. And this is just my handiwork, just to tell you what we're going to be talking about today, okay?
Okay,
We're just going to have two stops. I want to talk to you first about your interview with Dr. Parker,
okay,
and then I want to talk to you about the Newport News Public Schools protocols.
okay.
So, let's start with the interview of Dr. Parker. How soon after the events of January 6th do you recall conducting an interview of Dr. Parker?
From what I can recall, it was within 2 or 3 days.
And so sometime in early January still.
Yes,
And during that interview, did you ask Miss Parker whether she knew that a student had a gun on campus at Richneck Elementary before the shooting?
yes, I did.
And what did she say?
If I recall correctly, she said something was reported to her that a student had a weapon.
Would it help if I were able to show you a transcript of that interview to help refresh your memory?
Yes.
Yes, ma'am. Permission to approach, Your Honor?
You may.
Ms. Farish, just take a moment, or Dr. Farish, excuse me, take a moment and read the initial part of the transcript and tell me if it refreshes your memory as to whether this is a transcript of your conversation with Dr. Parker.
Yes,
Yes, it is.
yes, it is.
And if you can look onto page 2, line 19 of the transcript, can you just read that portion of the transcript silently? And does that refresh your recollection as to what Dr. Parker told you about what she knew or what she was informed of?
Yes.
And what was it that she knew?
She knew that students reported that a student had a weapon in his backpack.
And as part of your continued interview of Dr. Parker, did you learn who it was that informed her that a student had a gun in his backpack?
Yes,
And who was that?
Miss Kovac.
And as part of your interview, did you gather from Dr. Parker what time Dr. Parker learned that information? And if I can help you, it's on page 4, line 13.
Yes,
And what time was that?
12:20.
And as part of the information that Dr. Parker received about a gun in a backpack, did Dr. Parker share with you whether there was a plan to address it?
As I'm reading through and recalling, when you say plan, I'm not recalling a plan as much as the conversation of what happened.
And that's perfectly okay.
Okay.
And so is it fair for me to say, at least based upon the reports from Dr. Parker in that initial interview, she did not convey that she had formulated a plan to address it?
Correct.
And did she inform you during that interview whether there was a discussion with her and somebody else about searching the backpack? If it helps, page 3.
So it was Miss Kovac who searched the backpack.
And did Dr. Parker convey to you whether she was part of a conversation with Ms. Kovac where there was a discussion about searching the backpack?
Yes.
And that request came to Dr. Parker, correct? Or was it informed to Dr. Parker, whatever words that you think are most consistent with what Dr. Parker shared with you?
So it's my understanding that Miss Kovac checked the backpack on her own.
So if I can refresh your recollection on page 3, line 4, if you can read that to line 8.
Okay. So Miss Kovac was the one who...
You don't have to read it out loud. Just read it to yourself. That's okay. That portion that you just read, that was a portion of the transcript from Dr. Parker's own mouth, correct?
Correct.
So I'll ask you, just so it tracks what's there in front of you. Dr. Parker, according to her own statement, stated that Ms. Kovac was informed her, Dr. Parker, that she had already asked the student being JT, is there something in your backpack? Is that right?
Correct.
And the student had said to Ms. Kovac, at least from Dr. Parker's statement, that no, there was nothing in the backpack, correct?
Correct.
And then in the course of your interview, there was then a discussion about when the students go out to recess, and Dr. Parker conveyed that we can check the backpack. Is that fair?
Yes.
But Dr. Parker, at least based on the statements she conveyed to you, did not herself check the backpack.
Correct.
It was after recess, based on the statements of Dr. Parker, where Ms. Kovac asked her And what about his pockets? Is that fair?
Correct.
Your Honor, I would object at this stage only to, I've given counsel wide latitude, but I'd caution him against leading the witness.
Any objection to leading? Any response?
I'll rephrase to the
Thank you. That's sustained.
And during the course of your interview with Dr. Parker, was there information conveyed to Dr. Parker about pockets?
Yes.
And what was said to Dr. Parker, at least based on her statement to you? Page 3, line 17.
You want me to read it?
If you could, thank you.
And she says, but what about in his pocket? And I said, well, I don't know. Are they going out to recess?
Your Honor, I would object. This is improper refreshing of a witness's recollection. She cannot just read from the transcript. Again, giving him wide latitude, but let's keep it within the scope of the rules of evidence.
All right. I believe you've been refreshing her recollection.
I have.
All right. And so I'm going to sustain that objection. So you can't read out loud, so we need you to read it to yourself, and then if that refreshes your recollection, to answer Mr. Piniazzin's question, then you can do that. Does that make sense?
Yes, sir.
Okay.
Okay.
So, just to clean it up.
Okay.
Just to clean it up for a second. There was a conversation between Ms. Kovac and Dr. Parker that Dr. Parker conveyed to you, correct?
Correct.
And in that conversation, was there a question that was posed to Dr. Parker about pockets?
Yes.
Now, after the conversation with Ms. Kovac, did Dr. Parker share with you whether she learned from any other staff members of concerns of a weapon on campus? If it may help refresh your recollection, page 6, line 14.
Yes.
And who was that staff member based upon Dr. Parker's statement?
Mr. Rawls.
And did Dr. Parker convey to you what Mr. Rawls may have said to her?
Yes.
And having read the transcript of your interview, has that refreshed your memory?
Yes.
And what was asked of her? And I can ask a more tailored question to help here. Did Mr. Rawls ask at any point in time about checking a person based upon Dr. Parker's statement?
Yes.
And did Dr. Parker agree to having JT's person checked based on her statements to you?
No.
And based upon your interview of Dr. Parker, at what time did that conversation with Mr. Rawls approximately conclude based upon Dr. Parker's statement to you? Page 7, line 1.
1:40.
During your interview with Dr. Parker, did she ever state whether she personally left her office to go search a backpack for a gun?
No.
Did she inform you that she ever left her office to go check the student JT?
No.
Did she inform you whether she ever asked a member of the team, other teachers, anyone else, to search the person of JT?
No.
did she inform you whether she herself searched JT, as in, was he brought to her at her request to search him?
No.
Based upon her statements to you, did she contact the school resource officer?
No, not to my knowledge.
Based upon her statements to you, did she contact and notify the principal?
No.
Based upon her statements to you, did she call 911?
No.
I'm going to transition now, and I want to talk to you about the Newport News public school protocols, okay?
Okay.
Permission to approach, Your Honor.
You may.
You what's been pre-marked, and that means there's a little sticker at the bottom, and the number there is number 22. Is that correct?
Yes.
And there is a heading, or the title of that document is what, as best as you can tell? I know it's in big letters, but I'm not supposed to say it myself.
The whole cover, or just what the document is?
The whole cover, please.
Newport News Public Schools, Smart Safe Schools, Richneck Elementary, 2022-2023, Multi-Hazard Crisis and Elementary Management Plan.
Your Honor, I would object to the relevance of this line of questioning based on my prior motion in limine. I would incorporate my prior arguments, and to the extent that the court admits this evidence, I would seek a cautionary instructions to the jury, admonishing them that the written protocols do not set the standard of care or establish the existence of a legal duty in this case.
All right, so I've previously ruled on the motion. Your objection is noted, and then we'll allow the instruction. I believe that was my ruling on this matter.
Your Honor, we hadn't yet discussed what the substance of an instruction might
Correct.
be. And I just flagged that because we disagree with some of the statements that were made by counsel.
Correct. Well, I mean, we have to decide that at the
some
end.
point.
Yeah,
Yes,
at the
Judge.
end. We'll work that out in instructions. But your objection is noted currently, and it is contemporaneous.
Thank you, Your Honor.
All right, I think I'm going to explain to the jury how that works.
Yes, go ahead.
So in preparation for this trial, which we knew was going to take a while, we actually had a day of motions to try to streamline things as much as possible, because otherwise you would be up and down every time there was an objection. So I have previously ruled on the record on certain documents and evidence coming in or not. And what the attorneys have to do is when that evidence comes in, if they disagree with my ruling, they just need to put that on the record that they are, along with its entry, objecting that I allowed that in. And that's perfectly fine. That's how this is supposed to work. You're not to take anything away from that at all of any of my rulings. Those are legal rulings, and you don't need to concern yourselves with them. Does that make sense to everybody? Okay, so that's why that's going to happen. It's a good example of that. The next thing is we also agreed, not agreed on, but all the exhibits, and there are hundreds of them, have been pre-marked. In other words, they've already been given a number. So instead of having to have them marked, they would have to approach, I'd have to mark them, they'd have to be entered and go back. We've pre-done that, so you might hear that they're out of order, but the numbers will follow that exhibit throughout the entire case. All right? All right, thank you all very much. Thanks. Sorry to interrupt you.
That's okay. May I please report? May I proceed?
Yeah.
Ms. Farish, as part of your role in 2022, 2023 with the Newport News Public School System, you were made aware of this document, correct?
Correct.
And you were familiar with it enough to know it existed and some of the contents of it. Is that fair?
I cannot say that I am familiar with the contents of it.
Okay. If you could flip through the substance of it and tell me if, well, actually we can streamline this, Your Honor. This was a document produced by the Newport News Public School System, and based upon the stipulation Your Honor entered previously, it was deemed authentic by the parties. And so I'm going to jumpstart the authenticity part with Your Honor's permission.
All right, and that's agreeable with counsel, it is what it says it is, correct? All right, very well.
What that means, Ms. Farish, is we've all agreed that this is, in fact, the multi-hazard crisis and emergency management plan, okay?
Okay.
So what I would like for you to do is if you can flip to page 12 of that plan. And you're on a permission to publish?
Yes, over defense objection.
Yes. So just so the jury's tracking, this is the cover page that's in front of you.
Correct.
Talks about smart, safe schools, correct?
Correct.
And then it talks about multi-hazard crisis and emergency management plan. Is that fair?
Correct.
And that is specific in this document as to Richneck Elementary School.
Correct.
All right. Do you have page 12 in front of you now?
Yes.
On page 12, there's a portion here that talks about startup procedure. And I know it's hard to read. I'll be zooming in, folks. But is that the page 12 that's also in front of you?
Yes.
All right. So if we can zoom in here and we talk about the school threat assessment response protocol. Do you see that?
Yes.
All right. And there's a section here at the bottom that talks about procedures. Do you see that?
Yes.
Okay. And here it talks about, the first section, it talks about any student upon receiving information that a person is threatening to commit an act of violence shall. And the first thing is assume the threat is serious.
Correct.
And on page 13, it goes through responsibilities of students in the circumstance of a threat. True? Or we talk?
Yes.
And then here, when we get to this section, which is the third bullet point down, it talks about parents and guardians and their responsibilities. True?
Correct.
And then a little bit further down, we start talking about school staff members. Is that true?
Yes.
And in that context, we're talking about the teachers of the school of Richneck Elementary, as best as you understand.
Yes.
And again, it's assume the threat is serious, right?
Yes.
Immediately report the threat, right?
Yes.
Be available and cooperative to provide statements, right?
Yes.
And then the protocol changes and moves to the school administrator based on this document, correct?
Correct.
And then that responsibility is shifted and it says any school administrator, correct?
Correct.
And in this context, principals are administrators, correct?
Yes.
Dr. Parker was an administrator.
Yes.
And it says again, assume the threat is credible until and unless an analysis suggests differently. True?
Correct.
Judge, I just have to object to reading. Again, wide latitude, but patience is waiting.
All right, if you can, I'll sustain that and allow you to rephrase your question in a non-leading manner, please.
Does the policy talk about whether or not a school administrator should assume threats are credible or not credible?
Yes, it does.
And what does it say about that? You can read it.
Any school administrator, upon receiving information that a person is threatened to commit an act of violence, shall assume threat is credible until and unless analysis suggests differently.
And the next portion of this policy, does it talk about what, if anything, a school administrator, in this case, Dr. Parker, is supposed to do as it relates to the student making the threat?
Yes, it does.
And what does it say about that?
Cause the student making the threat, if known and on campus, to be immediately removed from the classroom and segregated into a secured area pending further investigation.
And is there a conversation within the policy or discussion about what should happen with other student or staff who may have received information?
Yes.
And what's the school administrator supposed to do in that context?
Segregate any student or staff member who received the threat pending further investigation.
And then there's Is there discussion about what, if any, requirements there are for the school administrator as it relates to the staff member who is a source of information for the threat?
Yes.
And what does it say about that?
Require the school staff member, if this is the source of the information, to provide immediate written statements regarding the information received.
And is there discussion within the policy about contacting 911 or a school resource officer?
Yes.
And what does it say the school administrator is supposed to do in that context?
Request police assistance either from the assigned school resource officer or by calling 911 for an emergency, or the nearest SRO for a non-emergency to report a threat.
Those are all the questions I have. Thank you, Ms. Farish.
Thank you.
Any cross-examination?
Yes, Your Honor, just a minute.
All right.
And I'd move Exhibit 22, pages 12, 13, and 14, which were the pages that were referenced into evidence, Your Honor.
All right, same objection, previously noted, now contemporaneous. Besides that, anything else?
I just asked that I remain a continuing objection there.
All right, granted.
Thank you.
So admitted.
So the record's accurate. Those pages are being moved in as number 22, and they'll be marked as 22.
Correct.
Yes.
I have no questions on this witness, Judge. Not at this time.
All right, no questions. So did you want her re-sequestered? Is she free to leave the building but be on call? How did you want to do that?
Asked her to remain subject to being on call, subject to the defense subpoena.
Okay. I'm assuming you'll go back to work?
Yes.
Okay. You have a cell phone?
Yes.
And has that been shared with the attorneys?
Yes.
All right. And how long will it take you to be here if we were to need you back? Just for planning purposes?
15, 20
15,
minutes.
20 minutes? Okay, thank you very much. So you are still considered a witness for this trial, so you're not allowed to discuss your testimony or anything you've heard, read, or said about this, and that continues until you hear otherwise from me.
Yes, sir.
Fair enough?
Yes,
Any
sir.
questions?
No.
Thank you for being here.
Thank you.
All right. All right, and you may call your next witness.
All right. Next witness is John Sims.
You can stand there and raise your right hand for me.
Do you swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Come up here, sir. Here, just walk your step. Just couple steps.
May it please the court.
You may proceed.
Good morning.
Good morning.
Can you go ahead and state your full name for the court reporter, please?
John Robert Sims.
And Mr. Sims, what do you do for work?
I am the music teacher at Richneck.
And back in January of 2023, what did you do for work then?
I was the music teacher at Richneck.
And
the acoustics are really bad. Can you speak up a little?
Yes.
All right, thank you.
and were you at work at Richneck Elementary on January 6, 2023?
Yes, I was.
I'm going to show you if we can publish the APIVA. On that day, Mr. Sims, Did there come a time where you spoke with Dr. Parker about concerns that were being shared in the school?
Yes.
And how many times do you recall having a conversation or being present for a conversation with Dr. Parker?
Twice.
So what I want to do is I want to talk about the first conversation, and then I want to talk about the second conversation separately, okay?
Okay.
So the first conversation. Do you recall when approximately during that day that happened?
Time-wise,
Yes.
probably between 11 and 12.
And when you say probably between 11 and 12, is there something that was going on? Or, in other words, was there recess before, recess after, lunch before, lunch after, that gives you a framework of when it might have been?
I don't know about the recess schedule, but I was sitting at the registrar's desk to cover the phones.
And so you said approximately 11 to 12, is that correct?
Correct.
And from 11 to 12, when you were sitting at the registrar's desk, was there a conversation that you had that triggered or resulted in you then going to speak with Dr. Parker?
Yes.
And who was that conversation with?
Mrs. West,
And who is Mrs. West?
one of the first grade teachers.
And what did Miss West tell you that led you to actually go to have a conversation with Dr. Parker?
She asked about the boy being searched.
And when we say boy, we're going to be using initials, so we'll say JT.
Okay.
Is that the boy that you're referencing?
Yes.
And what is it that Miss West asked about the boy being searched?
To my recollection, I believe she asked if he was searched.
And was why in the course of that conversation did you feel like it was right for you to then go to Dr. Parker next?
She asked me to ask Dr. Parker.
And so did you leave the registrar's desk then to go have a conversation with Dr. Parker?
Yes.
And do you recall what you might have said to Dr. Parker? Even if it's not verbatim, but
Yeah.
what the communication was.
I believe I relayed the message from Mrs. West asking if he had been searched.
And at that time, did you have any information or knowledge about why there was a question of the boy being searched?
Not to my knowledge, other than what Mrs. West had offered up.
And what was that?
That another student had come to her after recess about it, and so that's when I believe that's when, because I had called her about a different matter, and so then that's when she talked to me about it on the phone.
And when you say about it, I know we're in a courtroom and this is maybe tough. What is it?
About the gun.
And it was with that information that you then went to speak with Dr. Parker.
Yes.
And in the conversation with Dr. Parker, just so I'm tracking correctly, you asked whether he had been searched, that is, JT had been searched.
Yes.
And what did Dr. Parker say back to you?
I believe she said that the backpack had been searched.
And what did you do with that information after you received it?
I relayed it back to Mrs. West.
And when you say relayed, you weren't with Mrs. West face to face. You called her?
I either called her back or I had set down the phone initially and went back and picked up the phone.
And after you conveyed to Mrs. West that Dr. Parker reported the backpack being searched, was there another conversation that then led you to have a second conversation with Dr. Parker?
Yes.
And what was that conversation?
I believe Mrs. West called back to the office and I answered the phone again. And then she asked about if JT's person had been searched.
And when she asked you, that is, Miss West asked you whether his person had been searched, what did you do with that information?
I believe I said I wasn't sure, but I would ask Dr. Parker.
And is that what led you to then go have a second conversation with Dr. Parker?
Yes.
And when you went to Dr. Parker, where was she physically?
In her office.
And the first time you talked to her, where was she physically?
In her office.
Did you notice at any point in time between your first conversation and the second conversation whether Dr. Parker ever left her office?
No.
In other words, no, you never saw her, or no, you don't remember?
No, I wasn't really paying attention.
And she was there again when you went back for the second conversation?
Yes.
And when you got to her office for the second conversation, was there anyone else present around or in Dr. Parker's office when you got there?
Mr. Rawls was in the doorway. The other doorway.
And did you overhear anything that you can recall Mr. Rawls communicating to Dr. Parker?
I believe they were talking about the jacket.
And when you say the jacket, are we talking about JT's jacket?
Yes.
And do you recall anything about the jacket that they were talking about?
Not to my recollection.
Do you recall whether there was a conversation about what, if anything, to do at that point as it relates to JT?
Not to my recollection.
And did you participate in the conversation with Dr. Parker and Mr. Rawls at that time?
Yes, they were talking about the jacket, and I chimed in to say that Mrs. West had called back and asked about the jacket.
And what, if any, information was shared with you from Dr. Parker at that moment?
I can't recall.
Were you informed that by Dr. Parker that the jacket was checked?
Objection, Judge. He has his answer.
I'm sorry, what was the objection?
He has his answer. He has responded. He's not entitled to fish for the response that he's seeking. He asked a question, the witness responded. He does not recall.
So your objection is asked and answered, is that correct?
He is asked and answered, but he's stuck with his answer at this stage.
All right, your response?
Your Honor, I'm just ensuring that the witness understands the scope of my question, even if it's more narrow than it was
So you're
before.
rephrasing it, is that correct?
I will rephrase,
All right,
Judge.
I will overrule that on a rephrasing. Go ahead.
When you were part of this conversation with Mr. Rawls and Dr. Parker, did you hear Dr. Parker ever communicate that whether or not the jacket was checked?
Not that I recall.
At what point in time did you then leave that conversation with Dr. Parker and Mr. Rawls?
I believe I left after I had chimed in about Mrs. West calling back.
And did you then communicate back to Mrs. West any substance that you had learned from that conversation? And I don't need to know what it was. I'm just curious if you then relayed information back.
I can't remember.
That's okay. Thank you. Those are all the questions I have, Your Honor.
Cross-examination.
Yes, Your Honor. Morning, Mr. Sims.
Good morning.
Mr. Sims, you have multiple roles at Richneck Elementary School, correct?
Correct.
And that was true back in 2023 as well, right?
Correct.
You were a music teacher.
Correct.
You were also a resource team lead.
Correct.
You were also a testing lead. right?
Correct.
And by testing lead, I mean at Richneck Elementary School, like many public schools, it was subject to state mandated testing protocols, correct?
Correct.
And those are subject to strict regulations. You'd agree?
Yes.
I'm sorry?
Yes.
And if the school or administrators fail to comply with those regulations, they can be subject to sanctions, correct?
Correct.
Sanctions can include loss of licensure, right?
Correct.
There can be civil penalties.
Correct.
It's a serious consequence if you violate the state testing protocols, right?
Yes.
And so that's one of your obligations there at the school, is to ensure there's compliance as part of a team, right?
Yes.
At the time that this was going on back in January 6, 2023, they were doing testing at Richneck Elementary School. Do you recall around that time?
Yes.
They were doing annual statewide mandated testing, you remember?
Yes.
And Dr. Parker is responsible, in part, for ensuring compliance with those testing protocols, right?
Yes.
And that's actually part of what she was doing in that office, right?
Yes.
Objection, speculation.
He just seems to know the answer, Judge.
All right, why are you moving to strike his response?
Move to strike. Just lack of foundation as to what Dr. Parker specifically was doing.
All right, you have a response to that?
I can rephrase, Judge.
All right, so I'm going to sustain it on calls for speculation with allow you to go ahead and re-ask.
Mr. Sims, Dr. Parker, you were in or adjacent to her office at the time of these conversations, right?
Correct.
Her office is where she does her business, right? That's where she does her job as the assistant principal, correct?
Yes.
So it's not unusual for her to be in her office doing her job, right?
Correct.
But it was somewhat unusual for you to be in that office manning telephones, right?
Not particularly, no.
Well, let me rephrase. In your employment at Richneck Elementary School, were you a professional secretary?
No.
Were you trained to take down calls accurately? Did you receive specialized training in taking down calls?
No.
Ensuring that those messages were accurately relayed?
No.
Did you receive any training of any kind from school authorities there or in the course of your employment there to perform secretarial duties?
No.
But on that day, that's what you were doing.
Yes.
You were doing that because you were doing a favor for a friend, right?
Yes.
The registrar who normally mans the phones just wanted a lunch break, right?
Correct.
And so you went there and stepped in, as a good friend and colleague would do, right?
Correct.
And so then, later that day, you found yourself in the middle of this whole situation, right?
Correct.
It's fair to say. So I'd also say it's fair to say you didn't expect to be in the middle of the situation when you went to work that day, right?
Correct.
Plaintiff's counsel has talked about there were 2 calls, right?
Yes.
There were 2 calls that you received while you were in the main office there, right?
Yes.
At the time of both of those calls, Dr. Parker was near you, right?
Yes.
Can you describe the office? It's multiple rooms, right?
Yes.
It's not just one room and she's right next to you, right?
Well, kind of.
Well, let me be more specific. This room, the main office, it's called a main office for a reason, right?
Yes.
It's a communal space, right?
Yes.
People go in there to access the copier, right?
Yes.
There's a copy machine, fax machine, right?
Yes.
So there's traffic in and out of there pretty frequently, right?
Yes.
And also, like many main offices at public schools, students are there too, right?
Yes.
They're taken there for disciplinary reasons, right?
Yes.
And oftentimes, they're taken to the principal to await discipline, right?
Yes.
And that was the case on January 6th as well, right? January 6th, 2023.
What part?
At the time or around the time of these calls, there were actually 2 students or multiple students in the office at the time you received those calls. Do you recall that?
Yes.
And actually, that was part of why you placed that first call, right?
Correct.
The first call was you calling Miss Jennifer West, correct?
Correct.
Jennifer West is a first grade teacher, right?
Correct.
She didn't call you, right? Just to be clear,
Correct.
I know that sounds like a dumb question, but you called her, right?
Yes.
Any question in your mind about that?
No.
And when you called her, you weren't calling her to discuss a weapon, right?
Correct.
At that stage, you had no knowledge that there was a suspected weapon on the premises, did you?
Not to my recollection, no.
The first time you heard any information that there was a suspected weapon on the premises of that school was when you spoke to Ms. West, right?
I believe so, yes.
And when you went into that conversation initially, that was not your plan to have a discussion about there's a suspected weapon, obviously,
Right.
right? You were initially asking her, hey, there's 2 students here in the classroom, right?
Yes.
I believe they're your students. right?
Yes.
They got in trouble, right?
Yes.
So can they go back to class now?
Correct.
Right? And she responded,
They can go
recall?
back to class.
they could go back to class. And then she says, oh, by the way, right? Oh, by the way, there's some more information. Would you agree?
Oh, yes. Sorry.
Sorry. She says, oh, by the way, and your testimony today was that she let you know that there was a child with a suspected weapon in his possession, right?
Yes.
But you don't remember exactly what she said, right?
Correct.
It's been like 3 years at least, close to that, right?
Correct.
If you had to write down in detail, verbatim, what she conveyed to you, you would not be able to do that, right?
Correct.
But you've testified that once you received that information, she asked you to share it with Dr. Parker, right?
Correct.
And Dr. Parker, she was in the main office, right?
She was in her office.
Her office, which is part of the main office, correct?
Yes.
The main communal space, right?
Yes.
Where there's all this traffic, right?
Yes.
Right? And it's not like you're right next to each other. It is close quarters, but she's about like 20 feet away or so. Is that a fair estimate?
Probably, yes.
Right? And so to better estimate that, to go and talk with her, you don't just like yell across the room at her, right? You would have to get up and talk to her, right?
Not necessarily, because we were in eyesight
You had direct eye line vision,
from the desk I was sitting at.
okay? And she was stationed at her computer, right?
Yes.
And at the time that this was going on, she was involved in annual testing, right? That's why she was in the office.
Objection, same objection.
Yeah, you don't have to sustain that. If you can lay foundation for
I
that.
understand, Judge.
All right.
At the time that you were in the office with Dr. Parker, did she appear to be focused on her duties? Did
Yes.
she appear to be focused on her responsibilities as a principal working there?
Yes.
And also, you've testified that you shared some information with Dr. Parker. You can't tell anyone in this court, right, verbatim, what you told Dr. Parker, right?
Correct.
This is your ballpark estimate of your recollection of what you told her, right?
Correct.
3 years later, right?
Yes.
You've also testified that there was a second call, right?
Yes.
So, first call, you called Ms. West, initial discussion about the children and the discipline. And she says, by the way, here's some information about a potential firearm on the campus, right?
Yes.
When you received that information, you spoke to Dr. Parker, right?
Yes.
After you spoke with Dr. Parker, you've testified that her response was that the backpack had been searched, right?
Yes.
And then you called Ms. West and you told her that. You said Dr. Parker responded, the backpack has been searched.
Yes.
You cannot testify here today that when Ms. West called you, she shared where the firearm was. Said differently, you didn't know where that gun was at the time you were talking to Ms. West, did you?
No.
You didn't know if it was in a backpack, you didn't know if it was on this person, right?
Correct.
She did not share that information with you,
Correct.
right? And so when you spoke to Dr. Parker during that second phone call, you talked to Ms. West, right?
Yes.
Correct? You turn and say, this is important information. I have important information about a potential deadly weapon on Richneck property, right?
Yes.
That's important. You're doing your job. The job that you volunteered to do, right?
Yes.
And you turn and you convey this to her as best you can, correct?
Yes.
And she responds, the backpack has been searched, right?
Right.
Because at that time, it was reasonable to believe, well, I'll strike that question, Judge. There was no discussion with Dr. Parker about the weapon being on this child's person when you spoke with her, correct?
Not with me, no.
Focusing again on the second call. You end up talking to Ms. West and she gives you some more information, right? You continue speaking with her, right? And that's when this issue of the jacket comes up, right?
Right.
That was your testimony today, was at some point when you're speaking to Ms. West, there's a discussion about this child's jacket, right?
Yes.
And once you received that information, you said, I've got some more information now, right? I have important information. I need to share that with Dr. Parker, right?
Right.
And you tried to do that, right?
Right.
And you got up, right?
Yes.
And you walk across the office over to her room, right?
Yes.
To have that conversation.
Yes.
But when you tried to do that, you never had that conversation, did you?
I chimed in on the conversation that was happening.
Let's back up. When you first tried to approach Dr. Parker and share the information you got from Ms. West, Mr. Rawls had arrived, right?
Yes.
And before you could share the information you had received from Ms. West, Mr. Rawls had got there first, right?
Yes.
He had poked his head in there and he looked a bit concerned, frustrated even, right?
Yeah.
And when he was speaking to Dr. Parker, you couldn't hear everything that he was saying, right?
Right.
You don't know even what the beginning of the conversation was, right?
Correct.
You just caught the tail end of that conversation. Is that fair to say?
Yes.
And towards the tail end of that conversation, your testimony today was that you heard something about a jacket, right?
Yes.
But you can't tell this court, the jurors here today, specifically any details about that conversation, right?
Correct.
You just don't have that knowledge.
Correct.
I have no further questions of the witness. Thank you.
All right, any redirect?
Yes, Your Honor. Mr. Sims, there was a question posed to you as to whether Dr. Parker was focused on her duties and responsibilities. Do you recall that?
Yes.
And we've already talked about, and this is already in evidence, as Plaintiff's Exhibit 22, permission to publish, Your Honor.
You may, yeah, go ahead and
This is page 14 of Exhibit 22. This is the crisis management protocol. And do you see that front, that very top portion of this?
Yes.
And it talks about a responsibility of a school administrator. Is that right?
Yes.
What does it say?
The first one?
Yes, the first one that I've starred.
The school administrator shall take appropriate action to ensure safety of the students and staff.
And back in January of 2023, there was also a staff handbook at Richneck Elementary School. True?
Yes.
Your Honor, I would object to the stage judge.
All right, is this a document we've discussed previously in the motions?
No, we have not, Your Honor. I think we need a sidebar, or we need to have the jury excused for this argument.
All right, and what's the title of the document again?
This is Richneck Elementary School 2022-2023 Staff Handbook, Mrs. Brianna Principal, Dr. Ebony Parker, Assistant Principal, updated August 15th, 2022.
Has it been given an exhibit number?
Exhibit number 108.
All right, and not previously handled in motions day? Is that
Not specifically addressed.
okay. All right, and so what is your objection?
It was produced after Motions Day. It arrived last week for the first time, Your Honor. We had never seen this before. Never been produced in discovery, was not relied on by any expert, and showed up last week in two phases. One, someone had taken a screenshot, and then in a second, the full copy. And we objected that day on our supplemental objections to the witness and exhibit list.
All right. So you're arguing that that is it was produced late in the discovery process in violation of an order? That's correct.
It was just in violation of the rules of discovery, and it was also beyond the court's mandated time to disclose witnesses and exhibits.
Okay. All right. Mr. Benioff.
Your Honor, we received this exhibit late. We shouldn't have, and that's because it was requested from Dr. Parker during the course of discovery and not produced. And we had to obtain it through a third-party source. We obtained it past the deadline, and we disclosed it promptly. And now at this stage, we, based upon the line of questioning that was provided, we either intend to refresh the witness's recollection if he doesn't recall the handbook, or we intend to specifically introduce it into evidence if accepted by this court.
All right. So you're not moving it at this point. You are just crossing. Well, you're directing. You're actually on direct now. So I'm going to overrule the objection, allow him to direct on the handbook.
May I add something to the record, Your Honor?
Sure.
With respect to Mr. Benioff's statement that it was requested in discovery, as all discovery was objected to on the basis of the Fifth Amendment, on any questions related to handbooks. Mr. Benioff, the plaintiff, never moved to overrule the objection based on the Fifth, and to come in here now and say that we somehow did not produce something is not fair.
Okay. Overruled. Go ahead.
May I proceed, Your Honor?
You may.
Permission to approach the witness?
Yes.
Mr. Sims, I'm handing you the document, or I guess I just handed you a document that says Richneck Elementary School 2022-2023 staff handbook. Do you see that?
Yes.
Was this the staff handbook for you all at Richneck for that calendar year?
Yes.
And that included January of 2023?
Yes.
And earlier you were asked about questions as it relates to duties and responsibilities. Do you recall whether this document specifically discusses responsibilities of a school administrator, that is assistant principal, when it has to do with classroom management and safety? You can answer. Do you recall, without looking at it, whether it addresses that topic?
Not specifically.
Okay. If you would flip to, there's a little red number at the bottom that says 9074. If you go to that page. Does that refresh your recollection as to a portion of this staff handbook that addresses classroom management and safety?
Yes.
And do you recall, without looking at it, I know it's right in front of you, but do you recall, without looking at it, whether there are tiered behaviors within the handbook?
Yes.
Your Honor, I object at this stage to this line of questioning. I don't see how this is assisting the finder of fact. I would ask for a proffer from opposing counsel. What is the relevance of this?
Yeah, how does this go towards anything that was brought up in cross-examination?
Your Honor, he asked about responsibilities. The tiers within the handbook delineate responsibilities of administrators and staff members in situations of classroom safety. It's been the position of the defendants, both in cross so far and in opening statement, that there was responsibilities shared amongst individuals, and there's a handbook applicable to their relationships that tell us what their responsibilities were. If he didn't ask he asked the question about duties and responsibilities, and so we get to explore what duties and responsibilities were being attended to by Dr. Parker.
No, I'm going to overrule it. The door's been opened in cross-examination. Objection noted. Go ahead.
And based upon this staff handbook, there's level 3 behaviors. True?
Yes.
And what does it say about level 3 behaviors, as best as you recall? And if you need to refresh your recollection by looking at it, that's okay.
Level 3 behaviors are reported to school security and administration.
And is there a description is there a section that talks about student behaviors specific that are level 3 behaviors?
Yes.
And is there a student behavior within the handbook that specifically applies to a circumstance we're talking about here today?
Yes.
And what does it say?
Your Honor, I object at this stage. This is lack of foundation for the basis of this witness's knowledge. It sounds like he doesn't have any independent recollection of this document. He's just being asked to read from this document itself. To the extent that there was an argument about opening the door, I still stand on my prior objection, but this is a discrete issue. I mean, this is his bare recital by a fact witness of what is written in the internal policy. Has no bearing on the proceedings here. This has no bearing in this case. I would object on the grounds of relevance, as well as 2403 balancing, because this is going to invite the jury to render its verdict based on an improper basis that has no relevance. It's a collateral matter.
All right, in response to relevance objection now?
Your Honor, I believe the foundation was just laid with the witness that first, this is a staff handbook that applied in January of 2023. He was able to identify it as a staff handbook that applied in January 2023. And when asked whether there's a level 3 tiered behavior that specifically is pertinent to the issue here, he says yes, it's within the handbook itself. We've laid the appropriate foundation. It's certainly relevant to the issues in the case, especially in the circumstance in which the argument's been posed to the jury that this is a case about indifference and not inadequacy. And so what the individual knew, the defendant knew about their responsibilities and how to balance and weigh those responsibilities is certainly pertinent. And in light of the fact that they've crossed this individual on the fact that she was tending to her responsibilities on that day, it's relevant for us to address what other responsibilities she agreed and promised to keep.
Right. Overruled on foundation, relevance. I think those were the two latest ones. Go ahead.
Under student behaviors, is there a specific behavior that we've been discussing so far in your testimony?
Yes.
And what does that say?
Possession of a weapon.
And does this, as best as you can recall, or if you need to refresh your recollection, talk about what next steps and responsibilities to take next steps are on the administrator, the assistant principal?
To secure students and ensure safety.
Is there others?
Immediate notice to administrator and security. Email a detailed account of the incident and everyone's roles, names, locations, and time.
Now, you were asked about whether Dr. Parker focused on her duties and responsibilities. Based upon your observation of Dr. Parker during your first conversation, between your first and second conversation when she was in eyeshot and your second conversation and after, did you observe her attend or focus on any of those responsibilities?
Your Honor, I object. He's calling for expert testimony. He's not an expert.
I've overruled. All right, now you want to object that it requires expert testimony. I'm overruling that. Go ahead.
Do you recall the question? You want me to ask it again?
Can you ask it again?
Yes, sir. From the time that you had your initial conversation with Dr. Parker, and then you sat at the registrar's desk, you could see Dr. Parker. Then you had a second conversation with Dr. Parker. During any of that time, did you observe her take any actions that were focused on the responsibilities that we've just addressed in this handbook regarding the possession of a weapon?
Because of the position of the registrar's desk, I'm actually facing away from her door, so I couldn't tell you what she was or was not doing.
During your time there, did you see the student JT come into the administration office?
Not that I recall, no.
Did you see Dr. Parker leave her office to go potentially look for him?
Not that I observed, no.
Did you overhear her notifying security?
No.
Now, there was a question asked of you in cross-examination about not knowing where the gun was. You recall that question?
Yes.
Okay. Did you observe Dr. Parker take any actions to try and locate where the gun was?
Not that I recall.
Those are the questions I have.
Recross, Your Honor.
Yes, based on redirect.
Yes, Your Honor.
Sure.
You didn't see Dr. Parker take any actions after your conversation, last conversation with her? Because you weren't paying attention to her, right?
Correct.
No further questions, Judge?
All right, did you want him re-sequestered, on call, or is he excused?
Excused from our end, Judge.
All right, defense?
Judge, could we have him on call for the time being, but we'll be in touch shortly?
Okay. All right, so you're not being released as a witness at this time, but you are being released to go back to work, if that's what you're doing today. Do the defense attorneys have your cell number? Okay.
I don't.
No, all right, so well, actually, you've called him. Do you have his cell phone?
I do.
Okay. So how long would it take you to be back here at some point today, let's say?
Depending on traffic, 20, 30 minutes.
Okay. All right. So just with having said that, I'm going to let you leave the courthouse. You still are not allowed to talk about your testimony today. If you have to tell anyone where you were in court, and that's it. You can't talk about your testimony, read, or hear anything about this case until otherwise released. You understand?
Yes, sir.
All right. Thank you very much. I think now's a good time to take a break.
I agree, Your Honor. Thank
All
you.
right. All right, we are going to take our morning break now, about 15 minutes. Anything you need, just knock on the door and Sarah will assist you with anything that you don't already have, okay? All right.
Please rise for the jury.
More continuing coverage of the Abby Zwerner civil trial is coming up. Press subscribe now so you don't miss a moment. From the Hidden Killers podcast and True Crime Today,